Most people believe the ultimate goal of estate planning is incredibly simple. They think you set up a living trust and then you immediately dump every single asset you own directly into it. It sounds responsible. It sounds like the proper disciplined thing to do. But as a financial professional who has spent nearly 3 decades helping families guard their wealth, let me tell you the cold hard truth. Overfunding your living trust can be just as dangerous as not having one at all. Yes, funding your trust is essential, but trying to force certain assets into a trust can trigger immediate and devastating income tax bills, strip away vital legal protections, and leave your family with a bureaucratic nightmare when you are gone. Today we are pulling back the curtain on the 7 specific assets you should almost never title in the name of your revocable living trust during your lifetime, and the exact steps you must take instead to keep your transfer of wealth clean, tax-free, and fully protected. Oh, and if you stay with me until the very end of this masterclass, I'm going to give you an invaluable tool to get your inventory started. It is our signature emergency binder, and it is the exact document your loved ones will grab if all hell breaks loose, so they are not digging through drawers trying to piece your financial life together. I am giving it to you completely for free because I believe proper legacy defense should not have a price barrier. But first, if you believe that a lifetime of honest labour deserves to be fiercely guarded, not quietly surrendered to IRS tax traps or legal mistakes, do me a fast favour. Hit that subscribe button right now. Let us build your blueprint together and keep your hard-earned freedom exactly where it belongs, in your hands. When it comes to living trusts, the single biggest mistake I see is families spending thousands of dollars to draft a beautiful document and then either failing to fund it entirely or funding it with the wrong assets. I want you to write this rule down and keep it locked in your mind. Funding your trust is not about putting everything you own inside of it. It is about making sure every individual asset transfers the right way. Let us start with the absolute biggest culprit on our list, and it is the one that blindsides the most seniors: retirement accounts. I am talking about your traditional IRAs, your Roth IRAs, your 401k plans, and your 403b plans. Under federal law, you must never ever retitle these accounts into the name of your living trust while you are alive. These retirement accounts are already recognized as specialized trusts under the Internal Revenue Code. The moment you attempt to transfer the ownership of your active IRA or 401k to your living trust, the IRS will treat that transfer as a complete, immediate, and fully taxable lump sum distribution of your entire balance. If you have a $500,000 IRA and you sign a transfer deed, putting it in your trust today, you will trigger an immediate tax bill of upwards of $200,000 in April, destroying decades of tax-deferred growth in a single afternoon. So what is the correct move? You leave the ownership of these retirement accounts in your individual name. You do not touch the title. Instead, you coordinate them with your estate plan strictly through your beneficiary designations. For the vast majority of married couples, your primary beneficiary should be your spouse. Under the current tax code, a surviving spouse is the only beneficiary who enjoys the legal right to execute a spousal rollover, moving your retirement balance directly into their own IRA and keeping the tax-deferred compounding alive for the rest of their life. But what about the contingent beneficiary? This is where the trap lies. If you name your children directly as contingent beneficiaries on your retirement accounts, they will inherit those assets completely outright the second you pass away. In the eyes of the law, that means those inherited balances are completely exposed to their creditors, their ex-spouses, pending lawsuits, bankruptcy proceedings, and outstanding student loans. If your daughter inherits your traditional IRA directly and gets sued or goes through a difficult divorce, the court can order that retirement account to be liquidated and handed directly to her creditors. If you think the government protects inherited retirement savings, you need to understand a landmark unanimous decision by the United States Supreme Court called Clark versus Ramica, decided in the year 2014. In that case, a disciplined mother had built an IRA worth over $450,000. She named her daughter as the direct beneficiary. When the mother passed, the daughter inherited the account and shortly after fell into financial trouble and filed for bankruptcy. The daughter tried to shield her inherited IRA under federal bankruptcy laws, arguing it was protected retirement funds, but the Supreme Court ruled unanimously against her. They ruled that Because an inherited IRA is subject to different rules than an active retirement account, such as the requirement to take distributions regardless of age, it is not considered retirement funds. Under the bankruptcy code, the daughter's creditors were permitted to step in and seize the entire $450,000 legacy. A properly structured living trust could have prevented that financial tragedy. By naming your living trust as the contingent beneficiary of your retirement accounts after your spouse, the trust inherits the assets under the protection of a spendthrift or credit shelter provision. The money stays locked inside the trust, shielded from your children's creditors, lawsuits and divorces, while the trustee distributes the money to your heirs safely with guardrails in place. But you must also understand the tax implications of these distributions. Under the Federal Secure Act 2.0, non-spouse beneficiaries are legally required to completely empty inherited traditional retirement accounts within 10 years of your death. If your children are in their peak earning years, forcing them to withdraw hundreds of thousands of dollars over a 10-year window can push them into their highest historical tax brackets, triggering massive tax spikes. In retirement planning, we calculate this trade-off using a simple equation. When your heirs are forced to withdraw these funds, a single extra dollar over a critical tax threshold can trigger a devastating chain reaction, spiking their income taxes and quietly triggering double-digit Medicare premium surcharges 2 years down the road. I got so tired of watching honest, hard-working families get blindsided by these silent government premium spikes that I hired developers out of my own pocket, and we built an independent, ad-free utility called the Medicare Premium Shield. This tool is a completely secure and private utility designed to help you run your precise bracket diagnostics in under 2 minutes. You can check your thresholds, model your traditional IRA distributions, and protect your cash flow from these hidden government spikes. You can access the tool directly by opening your browser and heading to the web address medicarepremiumshieldforseniors.net, lifi.app. By making a one-time pay-what-you-can contribution of at least $15 to support our channel on our secure page, you will instantly unlock lifetime access to the live calculator. Go click that link right now, protect your retirement brackets, and then let us get straight to the second asset on our list. The second asset you must keep out of your trust is your health savings account and any old medical savings accounts you still have active. HSAs belong strictly to the individual. Much like an IRA, an HSA can only be owned by a living person. It cannot be transferred to a trust during your lifetime. If you attempt to change the owner of your HSA to your living trust, you will instantly destroy its tax-exempt status, and the IRS will treat the entire balance as taxable income. The simple, elegant solution is to keep the account in your individual name and coordinate your beneficiaries directly on the account custodian's forms. If your spouse is named as the primary beneficiary of your HSA, they can legally inherit the account and continue to treat it as their own HSA, keeping all the tax benefits intact. But if a non-spouse beneficiary inherits your HSA directly, the account immediately terminates on the day of your death, and the entire balance becomes fully taxable income to that heir in a single year. To prevent this year one tax bomb, you own the HSA individually, name your spouse as the primary beneficiary, and name your living trust as the contingent beneficiary to ensure that if your spouse passes before you, the remaining funds flow seamlessly into your trust protective structure. The third asset that trips up retirees is annuities. Because annuities often represent a substantial portion of your retirement nest egg, it feels natural to want to title them in your trust for probate protection. But you must understand that an annuity is already a contractual agreement with a legal insurance custodian. It already avoids probate through its beneficiary designations. And if you attempt to transfer the ownership of your tax-deferred annuity into your living trust while you are alive, some insurance companies will choose to treat that transfer as a surrender event. They will immediately liquidate the contract, trigger a massive tax bill on all of your deferred gains, and potentially slap you with heavy surrender charges. The right play is to keep yourself as the individual owner of the annuity, name your spouse as the primary beneficiary so they can continue the contract tax-free after you are gone, and name your revocable living trust as the contingent beneficiary to control the long-term cash flow after both of you have passed. This brings us to our fourth asset, standard life insurance. Many families believe they need to transfer their life insurance policies into their living trust to keep the proceeds out of probate. But life insurance already completely bypasses probate by contract law through your beneficiary designations. Transferring your active policy's ownership to your revocable living trust adds unnecessary administrative complexity without giving you a single extra benefit. The superior strategy is to own the policy individually, name your spouse or heirs as the primary beneficiaries, and name your living trust as the contingent beneficiary. This ensures the death benefit flows directly into the trust, where your credit shelter provisions protect the payout from your beneficiaries' lawsuits, divorces, or poor financial decisions. The only exception to this rule is for ultra-wealthy families with estates valued at over $30 million. For those estates, we use a specialised irrevocable trust called an irrevocable life insurance trust, or an ILIT, to hold the policy. This keeps the death benefit entirely out of your taxable estate, so your family is not hit with a 40% federal estate tax. But for standard planning, keeping the policy in your individual name and naming your living trust as the beneficiary is the ultimate move. The fifth asset you should keep out of your trust represents a major asset protection risk: your personal vehicles. I am talking about your daily drivers, your trucks, your boats, your RVs, and your personal watercraft. There are three distinct reasons why these should remain in your individual name. First, vehicles are depreciating assets that are incredibly easy to transfer to heirs after your death through your state's basic Department of Motor Vehicles process, or through simple transfer on death titles. Second, putting a daily use vehicle into your living trust is an absolute asset protection nightmare. If you or a family member are involved in a catastrophic car accident and the vehicle title is in the name of your living trust, the plaintiff's attorneys will immediately target your trust in the lawsuit. Instead of protecting you, you have handed them a clear public roadmap to every single asset your trust owns. By keeping the vehicle in your individual name, you isolate the liability and protect your broader portfolio. Third, car insurance companies get incredibly confused by trust-owned vehicles. You will face higher premiums, limited coverage options, and endless administrative hurdles trying to secure a basic policy. Unless you own highly valuable classic or collectible cars worth over $100,000, the juice is simply not worth the squeeze. Keep your daily drivers in your individual name. Our sixth asset category is regulated assets and professional licenses. I am talking about liquor licenses, professional practice permits, specific business charters, and restricted corporate shares. These assets are strictly governed by state, local, or professional boards that carry severe restrictions on who can legally hold ownership. If you blindly transfer a regulated license or professional permit into your living trust without obtaining explicit written approval from the governing board first, you can instantly invalidate the license, destroying a highly valuable business asset overnight. If you own these assets, always consult with a specialized attorney and your licensing board before making any transfers. Finally, our seventh asset, 529 college savings plans. Many grandparents and parents in our community have set up these plans to protect their grandchildren's education. But a 529 plan carries a very specific built-in ownership structure. You are the individual account owner, and your grandchild is the beneficiary. You cannot title a 529 plan in the name of your living trust during your lifetime. And the good news is, you do not need to. The account owner already retains absolute unilateral control. You can change the beneficiary at any time, or even claw the money back into your own pocket if an emergency arises. But what happens if you pass away? To keep the account out of probate and preserve the educational fund, you must verify that you have named your living trust as the successor owner on the account. During your lifetime, you retain complete individual control. But the moment you pass, your living trust steps in as the successor owner, managing the college fund for your grandchildren exactly according to the rules you wrote in your trust documents. My friends, true estate planning is not about blindly dumping every asset you own into a single bucket. It is about coordinating your entire financial life, your account titles, your beneficiary forms, your tax brackets, and your trust documents, so they work together as a single, unbreakable firewall. To help you take immediate action this week, I want to give you our Master Emergency Binder completely for free. This is the document your family will desperately need when all hell breaks loose. It coordinates your entire financial life, your accounts, your assets, your key contacts, and your personal instructions in one secure, accessible place. You can download your free companion binder instantly using the first link in the description below. Get the binder, start your inventory, And if you need professional help mapping out your tax brackets, protecting your portfolio from sequence of returns risk, and coordinating your estate, you can schedule a completely free strategy session with one of our independent registered professionals using the calendar link on our secure page. Before you go, drop a comment below. Have you checked your beneficiary forms recently, or have you watched a family struggle because of an uncoordinated asset? Let us talk below. I am Warren Greystone. This is the Retirement Blueprint. Click the first link in the description, download your free binder, protect your brackets, and I will see you in the next breakdown.